I'm very happy to be here speaking on the topic of climate litigation. And really what I'm going to speak about today is the idea of how climate litigation helps promote the concept of environmental crimes. So I want to thank you for having me here today and inviting me to speak. So as we all know, the topic of climate change and sustainable development have been at the top of the agenda, you could say. However, despite substantial discussion on the importance of preserving the environment as a whole, the international community still seems to struggle somewhat in successfully balancing between environmental considerations, economic considerations, political will, and so on. And there's a suggestion that the protection of the environment must be enhanced, not the least through the introduction of criminal liability, as many of you have already spoken about both today and yesterday. Now, thus far, the efforts to establish such provisions at the international level haven't been as successful as we'd like them to be. And as it stands, international law at present doesn't really impose criminal liability for environmental damage, at least environmental damage that results from peacetime activities, even where the damage is quite substantial. So if we look at the current criminal code at the international level, the Rome Statute, it doesn't engage environmental damage to the way that we would like it to. It doesn't have the right application in a way. So it does engage environmental damage. However, the only provision that really deals with environmental damage is Article 8, subsection 2, B4, which imposes criminal liability for internationally launching an attack in the knowledge that such an attack will cause widespread, long-term, and severe damage to the environment, which ultimately means that this provision is largely limited to damage or destruction that's caused during armed conflicts only, due to that wording, that particular wording of intentionally launching an attack. Now, when we look at Article 2B, it also could be connected to the environment. However, that provision is limited to damage done in relation to civilian property, which covers the environment only to the extent that it is property. So it really covers the environment only to the extent of the environment being an extension of human needs, as an extension of what humans own as property. So criminal liability for environmental damage could also actually be engaged under Article 6 of the Rome Statutes, which is the article that defines genocide. And it defines genocide as any of the following acts committed with the intent to destroy, in whole or in part, the national, ethnical, racial, or religious groups, which according to Article 6C also include deliberately inflicting on a group conditions of life calculated to bring around physical destruction, in whole or in part, which could also refer to the destruction of the environment. Having said that, again, the crime is limited to the circumstances where environmental damage that is committed is done so with the intent to destroy a particular group only. When we look at Article 7 on the crimes against humanity, we could also potentially see how that could engage with environmental issues. However, again, we see the applicability of these provisions is limited, since in order to be considered a crime against humanity, the crime must be executed as part of a widespread or systematic attack against a civilian population. So we see somewhat an engagement with environmental issues. However, in practicality, it doesn't necessarily apply to environmental damage within peacetime. What I will mention is that there has been obviously attempts to incorporate environmental crimes into the criminal code, which was a provisional inclusion of Article 26 in 1991, and the draft code of crimes against the peace and security of mankind. However, due to differences of opinions amongst the states, Article 26 was removed from the final version in 1996. Now, what Article 26 actually had in there, it imposed criminal liability on individuals who willfully cause or order the causing of widespread, long-term, and severe damage to the environment, which was not what people today envisage as a crime of ecocide, since Article 26 was a little bit different and it involved willful damage, so willfully damaging, and also imposed criminal liability on individuals only, while the crime of ecocide functioned a little bit differently. The crime of ecocide envisages a strict liability provision for severe environmental damage that would apply to anyone, including individuals, corporations, states, and it would disregard intent. However, nevertheless, this Article 26 was early formation of this legislative environmental crime. So the issue today is that apart from the inherent limitations that we have with the Rome Statute, that the crime must be committed with the intent and the knowledge and the inherent approach of the international criminal system, that criminal liability applies only to individuals, and that the question for criminal liability for states is a political matter that can't be determined by the court. And there are inherent inhibitors that make the inclusion of environmental crimes substantially difficult. The first inhibitor that we really come across is the jurisdiction of the ICC, and it's limited to the most serious of crimes of concern to the international community as a whole, which means that in order for an environmental crime to be considered, the crime would need to be of the utmost seriousness, which would not only that the scope of the environmental crime that could be addressed in the Rome Statute must relate to extreme damage or destruction. This also provides that the international community would consider environmental damage or destruction as a serious offense in the first place. Currently, the ICC has jurisdiction to hear cases that relate to 4 categories of crimes only, which are considered of the utmost seriousness, and those are the crimes of genocide, crimes against humanity, war crimes, and crimes of aggression. So environmental crimes are also not necessarily supported by the framework of international law. And there are some conventions that impose criminal liability. So for example, smuggling certain animal species. However, these conventions are subject specific and don't cover the environmental as a whole. So they're not far reaching enough. And so one of the problems that we see here is that according to Article 2.1 of the Rome Statute, the applicable law for the cases before the court is that, and to quote it, in the first place, the statute, elements of crimes, and its rules of procedure and evidence. In the second place, where appropriate, applicable treaties and principles and rules of international law, including the established principle of international law and armed conflict. And third, failing that, the general principle of law derived from the court from national laws of legal systems and the world, including the national laws of states that would normally exercise jurisdiction over the crime, long as those principles are not inconsistent with the Rome Statute and with international law and international recognized norms and standards. So considering that international law doesn't prescribe criminal liability for environmental damage per se, let alone that the International Environmental Law Conventions generally provide soft obligations, and that the word ecocide doesn't necessarily at this stage have the support from the international conventions that matter would move to the national law systems and prescribe criminal liability for environmental damage at that level. One of the other associated issues that we see with the jurisdiction of the court in the first is that the court in the first place is a complementary system. And in a way, it's somewhat subordinate to national law. So the ICC doesn't have jurisdiction to hear cases, whether the case is being investigated or prosecuted by the state, which has jurisdiction over the case, unless the state is either unwilling or unable to genuinely carry out the investigation or prosecution. Or if the state decided not to prosecute the person concerned, unless the decision resulted from an unwillingness or inability of the state to genuinely prosecute. So even further, the jurisdiction of the ICC also operates on a voluntary system, which means that unless the case is referred to the ICC by the UN Security Council, for the ICC to have jurisdiction, the concerned state must either be a signatory to the Rome Statute or voluntarily accept the jurisdiction of the court, which in itself limits the outcomes that are expected from the inclusion of an environmental crime within that code. So now that we've talked about some of the issues in relation to how we phrase this as an environmental crime, one of the things I want to talk about now, and really the focus of this presentation, is looking at climate litigation and the contributions that climate litigation has made in promoting this concept of environmental crimes and in promoting environmental crimes at the national level, but particularly at the international level. And to do so, I really want to focus on 2 case studies. So the Uganda case and the Portuguese Use Case. So considering everything that was said so far, the question is really whether, and if so, how climate litigation can promote the development of an international criminal regime and international crimes. What is noticeable is that many of the cases today are brought under international human rights law, and also certain standards are developing that may contribute to the development of environmental crimes. And so you'll see, particularly with these two case studies, a lot of it is framed around this idea of human rights. Having said that, this has developed the jurisprudence, particularly in that area, as environmental issues being brought under the human rights legislation, but it's also made numerous contributions to the idea of promoting environmental crimes and work towards an appropriate regime. So let's have a look at the Urgenda case first. And this is where Urgenda brought a claim against the Netherlands for not meeting its emission obligations. And to give you a little bit more information, the Urgenda climate case was against the Dutch government and was the first in the world really in which citizens established that the government has a legal duty to prevent dangerous climate change. So in June 2015, the District Court of The Hague ruled that governments must cut its greenhouse gas emissions to at least 25% by the end of 2020, as compared to the 1990 levels. And the ruling required the government to immediately take action on climate change. The District Court's decision was then appealed by the state and upheld by the Court of Appeal in 2018. And then following that judgment, the state appealed it to the Supreme Court. And on December 2019, the Dutch Supreme Court, which is the highest court in the Netherlands, upheld the previous decision, finding that the Dutch government does ultimately have obligations to urgently and significantly reduce emissions in line with human rights obligations. So the decision of the Supreme Court of the Netherlands was that the European Convention on Human Rights imposes positive obligations, which requires the Dutch government to take measures to prevent climate change, despite the fact, and this was pointed out by the courts, that the Netherlands ultimately isn't a major contributor to climate change on a global scale. Having said that, it still found that the Netherlands had an independent obligation to reduce its emissions, and that in the minimum, the measures should ensure that the Netherlands does fulfill its obligations to reduce its greenhouse gas emissions by the end of 2020. Now, one of the things that was attached to this case was, and on reflection of the case, was that the UN High Commissioner for Human Rights published a news release following this decision. And what it stated in there is that the decision confirms the government of the Netherlands, and by implication, other governments, have a binding legal obligations based on international human rights law to undertake strong reductions in emissions of greenhouse gases. Now, this case was actually brought on behalf of just under 900 Dutch citizens, and it made climate change a major political and social issue, both in the Netherlands and globally. And what we saw post the Urgenda case is a significant number of climate cases being brought up around the world, in Australia, Switzerland, the UK, Canada, Colombia, Germany, France, so popping up all over the place. And in this particular case, what the court actually found was that the Supreme Court held that appropriate measures were required to be taken where there was a real threat to lives and the well-being of individuals within the state. And according to the Supreme Court, this applies to environmental threats that may not just have an immediate effect or a short-term effect, but then a longer-term effect. And also threats that have a real and immediate effect, even if there's a long-term risk associated with a more immediate effect. Okay, so the idea here was that there was a serious risk that the current generation within the Netherlands will have a serious loss of life, their family life affected, and this was some of the things that the court had discussed. Now, it therefore follows, Article 2 and Article 8 of the European Convention of Human Rights. It states that the state has a duty to protect residents from these kinds of real threats. The second question that the court really dealt with in this particular case was what actually does this responsibility mean? So here the court developed this notion of a fair share of global responsibility, and that a state can't basically, avoid their responsibility by claiming that they aren't a major contributor to climate change on a global scale compared relatively to other states. And part of the reason that the court had that rethink is because if we accept that kind of argument that we're not a major contributor, therefore we can't be held liable, ultimately that would negate the effect of Article 2 and Article 8 of the European Convention of Human Rights. And those rights would ultimately would not be protected effectively. So another question comes up there. So what then is it that the state needs to do to fulfill that responsibility? And here the court actually referred to the 2007 IPCC reports. And it mentioned the figures that had been done there of decreasing emissions of industrialized countries by 25 to 40% by 2020. And so we also get this question of then, okay, so what do we actually need to do to fulfill this responsibility? And that in itself is very much an evolving answer. The Supreme Court also, within its reasoning, discussed the consensus within the community. So within the science community, within the international community, that the longer we postpone the measures that are required to tackle climate change, the more expensive, the more difficult it will become. And so that postponement also creates a greater risk of climate change and therefore a breach of human rights. So now, even though the court decided on the lowest end of the reduction target, even though within the court's assessment, the reduction target reflected, the urgent needs of the states, the findings of the court does establish a standard for what levels of emissions is permissible and what level of emissions is not permissible. And if we consider that within the context of environmental crimes, it could provide a base for determining what could be considered severe damage. It does present that kind of possibility. Another contribution that was made by the Urgenda case is that since the court reviewed the relevant sources that refer to an emission target, the court also brought to the fore the growing level of impact of soft law instruments, which, considering the lack of jurisprudence in this area of environmental crimes, that's significantly beneficial, since the majority of instruments that deal within this area are soft law instruments. And I would also say that another contribution made by this case is a claim was made against the state as a whole. And if the notion of claims against states is adopted, states may start to reconsider their conduct as well as their policy, which may lead to reductions in emissions, thereby promoting the Paris Agreement, which by the end of the day is a general aim. And that would, in a way, I suppose, reduce the need for criminal liability for extreme cases in the first place. Now, for example, with this case, the Dutch government's response was a commitment to reduce the capacity of its main coal-fired power stations by 75%, and to implement a €3 billion package for the measures to reduce Dutch emissions by 2020. So in effect, by finding the finding of the court here not only signifies to the state's legal position, but it also promotes things like public knowledge, public opinion, public participation, which increases the risk for litigation for states. So I want to talk now about the Portuguese use case, which is a really good second example of the potential impact of climate litigation on the development of environmental crimes. And again, with the Portuguese use case, this one's an interesting case because it was an application made directly to the European Court of Human Rights by 6 Portuguese children and youths who ultimately were seeking that 33 state members of the Council of Europe had breached the Convention of Human Rights, and in particular, Articles 2, 8, and 14, which relate to the right to life, the right to private and family life, and discrimination, respectively. Now, the application was brought on the basis that 33 states, including 27 EU states, Norway, Russia, Switzerland, Turkey, the UK, and Ukraine, had failed to sufficiently reduce their emissions due to the import of goods containing carbon, the export of fossil fuels, and the contributions of entities within their jurisdictions to greenhouse gas emissions, as well as their contribution to greenhouse gas emissions in other jurisdictions. Now, the argument here centered really on the rising threat of climate change, which poses a significant threat to both physical and mental well-being. And the Sikhs also argued that they were being discriminated against based on the idea that young people suffer most from climate change, and that's expected to worsen over time. So on the list of questions sent to the court, it was asked whether the youth applicants under Article 3 of the European Convention of Human Rights was also violated. And when we look at Article 3, what Article 3 actually says is that no one shall be subject to torture or inhumane and degrading treatment or punishment as a result of the effects of climate change. So one of the interesting facts here is that the European Convention of Human Rights, the European Court of Human Rights only considers complaints that were previously brought before national courts and requires the exhaustion of domestic remedies as one of its admissibility criteria, set out in Article 35 of the European Convention of Human Rights. Having said that, in this case, the plaintiffs filed their complaint directly with the court without first going through the Portuguese national courts. And the applicants argued here that the 33 countries in which they were bringing the case against actually shared an international responsibility for contributing to climate change. And going through the cost of litigation nationally, which would be both lengthy and expensive, wasn't actually an appropriate mechanism for bringing this action. And they stated that the nature of their action was much more of a transnational nature. And so what we see is one of the interesting developments, the first interesting development that we see from this case is the fact that this was allowed, that it was actually admissible within the international court without going through the national levels. And so what we see here is an indication by the courts of willingness to consider the merits of this case. So the court also announced that it would deal with the case as a matter of priority under Article 41 of the Rules of the Court. And what Article 41 says is that in determining the order in which cases are to be dealt with, the court shall have regard to the importance and urgency of the issues raised and the basis of criteria fixed by it. So the chamber or its president may, however, derogate from the criteria so as to give priority to a particular application. Okay, so we see that as another really interesting aspect stemming out of this particular case, that this, a climate change litigation, one that hadn't gone through the national courts, is actually being given priority at the international level. So now there are two particular aspects I want to discuss that arise from the application that do make a contribution to the idea of the development of international crime regimes. And the first is the claim that was brought against the 33 states, which is a significant number of states and that allegedly have breached their obligations. And that emphasizes the need for a stronger regulatory regime and requires that all areas of international law are required to engage in this subject matter, or at least through the imposition of a criminal liability for serious offenders. The second potential impact here is that if the court was indeed to grant the declaration, the likelihood is that all, or at least the majority of these states would develop new policies and standards of conduct, which ultimately, aside from the beneficial policy aspects, can lead to the development of new customary international law, which, if that would be the case, would ultimately enable to bring claims for criminal liability against the states pursuant to Article 40 of the Articles of Responsibilities of States, which provides that a state may be criminally liable for a serious breach of an obligation arising under preemptory norm of general international law. So whether this may prove an effective mechanism, however, is somewhat uncertain, you could say, pursuant to Article 40. The elements for establishing such a criminal liability must breach both a preemptory norm, but also meet the definition of serious, which pursuant to Article 42 means that the breach must be gross and systematic, and it requires a very high threshold, which would likely apply only in very extreme circumstances. While it's narrow, however, it does present a development nonetheless. So, okay, just to finish up, I'd like to point out some of the other benefits that we do see coming from climate change in general. And the first benefit here is really that the more claims that we see brought, we see with relation to environmental damage or destruction before the courts, we see the likelihood that new precedents would be set, and not only to develop and clarify the law that's applicable in this area, applicable to environmental damage in the context of global warming. More litigation is also likely to result in the understanding that policies in environmental matters are needed and potentially in more enhanced regulatory regimes. And that may lead to behavioral change, both within the governments and non-governmental actors. Litigation against corporations that are major emitters could also result ultimately in a drop within those emissions, also result in a drop in corporations' share value. And that itself could provide a motivation for change both within their policies and their conduct. I would say this ultimately could also then stem stricter regulations within specific industries. And climate litigation, therefore, is also likely to promote mitigation efforts. In relation to future generations, the systems of separations of powers means that considerations of the effect of today's conduct are made free of political and economic influences in a way. And I would say that the courts themselves may contribute to the development of law and the enhancement of environmental protection. So a couple of other things that we just before I finish off that really pop out from some of the things that we've been discussing today is that we see a development of legal standing as well as a development of state liability with regard to action or inaction on climate change. And we've seen a lot of success in that regard. In addition, though, I would state that we have also seen judicial enforcement of corporate accountability for climate change and development with regard to how we understand and apply this idea of cause and effect, and particularly the significant case law on corporate liability in this area within the ASEAN communities. What we also hope to see is that the number of cases and verdicts increase and that there is increased pressure, but also increased attention by parliamentarians and policymakers with regard to the effect that it'll have on the legislative and judiciary bodies and the need for them to address climate change as an issue, both at the national level, so within the national legislations, but also within the national legislations when they transpose their international obligations. So you can see that there's a number of different obligations here. And I think just to finish off, one of the really interesting things that we see is so Joanna Stetzer and Rebecca Bynes in their report, Global Trends in Climate Litigation, which was released in 2020, really make reference to this idea that climate litigation can have direct and indirect regulatory impacts. And they base that on Peels and Osofsky's work in 2015. And although this is largely written with reference to the national level, I think it does have resonance in the international level too. And ultimately divides the impact of climate litigation into two halves, the direct regulatory impacts and the indirect regulatory impacts. And when it's talking about direct regulatory impact, it's really talking about the changes we see within litigation, such as targeted rules, policies, decision-making procedures, judgments within the court, and the interpretations developed by the courts. And when it talks about indirect regulatory impacts, it really talks about the ongoing effect, the flowing effect from litigation that talks about behavioral change at the government level, at the corporate level, at the non-government level, a sensitization, to use their wording, of legal institutions to the nature of climate change, increased public awareness, our perception of litigation risks, and this is an interesting one, the perception of states, corporations, and governments of this litigation risk. So I'm going to finish up there because I'm pretty much out of time, but you can see that although climate litigation in a way hasn't brought around any potential, environmental crimes regime per se, it does have significant impact on the ability to form that environmental regime, to understand what it could look like. So thanks so much, and I'll leave it there.